Hey guys, it's Kathy. Happy birthday, CJ. I know, Jen, that was so rude of me. I won't do that. I might do it again. I'm not going to lie. It's not fair though. I'm first because I clicked the button. I'm the button clicker. Hey CJ, thank you for waking me up today. Appreciate it. I'll try harder in the future. All right. We are part 3 of March 6th. So I don't think we're going to get through March 6th today, but we're getting there, guys. We're getting there. There we go. Let's get to it.
If there is certain evidence pointing in one direction, you'd be remiss not to follow up on it.
Right,
That's the situation here.
Doesn't that mean you also should follow other evidence also?
If it's available, if there is other evidence, we certainly would.
And did you follow up in this case, the other evidence regarding drugs?
There was no other evidence.
Did you talk to Faye Resnick personally?
I did not.
Did Van Adder talk to her personally?
I believe he interviewed her, yes.
Is that a tape statement?
I believe it is.
Will he be testifying later on this week?
I don't know.
Still your partner?
That's correct.
You've talked to him about his conversation with Faye Resnick, did you not?
Briefly.
Did you talk to anyone else in your superficial examination or investigation regarding the aspect of drugs?
No.
In the course of your investigation, does the Los Angeles Police Department ever use dogs for tracking or maintaining scents in any homicide case that you know about?
I've never heard of that.
You've never done that in the 20 plus years you've been a homicide detective?
Never done it. I've never heard of it.
Now, right before we broke today at lunch, I was asking you about hairs on the gloves. Do you recall that?
Yes.
Do your reports indicate whether or not there were Caucasian hairs on the glove found at Bundy?
The report does indicate Caucasian hair, yes.
All right. Were there any Caucasian hair found on the other glove that was found?
That's my information, yes.
On both gloves?
I believe
Caucasian hairs?
so.
Were there Negroid hairs found on either or both of those gloves? If you recall.
I don't recall.
Forgive me if I asked you this before. With regard to this walkway where the bodies were found, what is the width of that particular walkway? If you can tell us.
Offhand, I believe it's 3 feet 11 inches or 4 feet.
Right at 4 feet?
Approximately 4 feet. I
And
believe
if-
it varies.
I'm sorry.
I believe it varies a little bit.
Okay, but somewhere close to 4 feet. Is that a
Yes.
fair statement? If you recall, did your partner, Detective Van Adder, change clothes at all on the afternoon of June 13th, 1994?
I don't recall him changing clothes.
You have no recollection of that?
I don't think he had any clothes to change into.
All right. Were the two of you in separate cars when you left Parker Center?
Yes,
You drove back to Rockingham separately?
that's correct.
The vehicle that Mr. Kalin had parked the curb there at Rockingham in the morning, early morning hours of June 13th, was that a Nissan Z vehicle?
I believe so.
In your report at the Bundy crime scene, I think there's a reference to a dumpster in the alley. Is that dumpster in the alley, do you have any photographs of that, where that was located?
Yeah, I believe there are, yes.
And was that one of the places that was searched for either bloody clothes or weapons or knives or things of that nature?
Yes,
And I presume you didn't find anything in connection with this case, right?
that's correct.
Now, in that connection with regard to knives, you recovered a number of knives that were turned into you in connection with the search or searches done after June 13th, 1994. Is that correct?
Yes.
Did you participate in purchasing a knife yourself?
No.
Now, with regard to Mr. Goldman, and did your investigation at any point turn up that he was a young man who worked out regularly, was physically fit?
That's my understanding.
and that in some of the cards that you found in his materials, you saw the card of a personal trainer and a gym that he might have attended also, did you not?
I believe there was one, yes.
And were you able to ascertain how many wounds, if any, he sustained at the time of his demise?
It's kind of vague, isn't it? Wounds?
Yes, sure, certainly are. Thank you. Were you able to ascertain how many times Mr. Goldman was stabbed during the incident in which he met his death?
Oh, were you present at the autopsy?
Yes, Your Honor.
Next question.
Were you able to ascertain?
Seems to me there were 7 or 8 stab wounds.
7 or 8, is that the total number?
As far as stabbing wounds, I believe so.
And were there other wounds?
There were slashing wounds, superficial cuts,
All right, so
I believe a contusion,
stab wounds, slashing wounds, contusions.
abrasions, contusions to the rear of the hands and fingers.
Altogether, how many wounds were there, if you know, based upon your observation of the autopsy?
As to each abrasion and contusion,
Yes, altogether.
I would have no idea. If you were to count each abrasion and each contusion on each finger and the back of the hand,
I understand.
as far as fatal wounds, I believe there were something like 4 fatal wounds.
Now, in the course of your investigation in this matter, did you at any time ever investigate any relationships with Mr. Goldman may have had to determine whether or not he had any enemies, anything of that nature?
I spoke with a former girlfriend, and there were other interviews by other detectives.
All right, let's talk about what you did. When did you do that?
I don't call specific.
Well, approximately, when did you have this interview?
There's an interview on file. I don't recall. It was, I don't know.
All right, is that the only interview that you conducted, sir?
In
Personally?
regards to a former girlfriend, I believe, yes, the only one I conducted.
Did you talk to any other former friends or present friends?
Personally, I did not.
Did you have occasion to investigate Mr. Goldman's contact with a business called Design Wrap, W-R-A-P?
I did not.
Did anybody under your direction do that?
I would have to look. I don't recall that.
And where would you look?
Much of that investigation initially was conducted by Detective Tippin and Carr, perhaps in their log, perhaps in their book.
All right. Now, at the crime scene, among officers and people who come to a crime scene, eating and drinking are not permitted. Isn't that correct?
Yes.
And officers are trained not to eat and drink at crime scenes. Isn't that correct?
In the specific crime scene, certainly that's correct, yes.
And you testified in this matter, at least earlier, that if you saw someone doing that, you jump on them right away, right?
If I saw them, yes.
All right. And if you saw even anyone from the coroner's office eating or drinking, you would curtail that activity also, wouldn't you?
Yes.
Something that you wouldn't want to have. Is that correct?
If it were outside of the crime scene, I don't have a problem with it. If it were certainly near evidence, certainly near the bodies, yes.
We're talking about inside the crime scene.
That's my same response.
And with regard to someone smoking, you wouldn't allow that either, would you?
Not at the crime scene.
In the crime scene. Now, last week when I asked you, you were sharing with us that you took these sneakers and you put them in the trunk of your car and took them home. Do you recall that?
Yes.
I'd like to show you a video at this point now, if I can.
Yes, we have.
Oh yeah, we
Yes,
saw
see
it.
With the court reporter, please.
What? We saw the video. He threw him in his back seat. He didn't put him in the trunk with the ice cream.
As far as the jury is concerned, we're going to stand in recess now until tomorrow morning at 9 o'clock. I need to look at some videotapes out of your presence. Remember my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't let anybody contact or communicate with you with regard to the case, nor are you to perform any deliberations till the matter has been finally submitted to you. All right?
Didn't we see this?
We'll see you back
We saw
here
it.
tomorrow
Didn't we
morning
threw
at
him in
9
his
o'clock.
back seat and drove away?
All right, Deputy McNair, let's take the jury. Yeah, Mr. Harris, why don't you hold it there? All right, Detective Lang, tomorrow morning, 9 o'clock.
Yes, John.
Thank you. All right, witness says withdrawn from the courtroom, Mr. Harris.
It's not a sidebar, so I can't fast forward it because I don't know. Okay, they're talking.
Since we have the VCR running at this time, may I inquire of the defense, is there any other videotape that they wish to show the witness? They've alluded to people eating and drinking and other things already.
You know, this videotape, I believe, is the one we played on January 24th. That's already been marked and is a court exhibit. There was a second videotape we played in connection with the opening that didn't get marked, but it was played. The defense was provided a copy, or the prosecution, of both of those tapes back around the time of opening. Since this excerpt was made, I took all of the tapes of clips that we have, put them all on a 2-volume set, which was provided again to the prosecution, I think on Friday. 2 volumes. It has everything put together. There's a lot of duplication, but it's all there. So they've had this for quite some time. They have it again. They can look at it anytime they want. Those are all the videos that we have up until we recently subpoenaed some more from some television stations. I don't know. We're still waiting for those to come in. But up until a week or so ago, this is everything we have, tapes from all the stations.
You know, I appreciate counsel's invitation to us to look at the videos that he's given us, but we have hours, a number of hours of videos. So we can't anticipate which 10-second segment of the hours of videos they've given us that they intend to present to a witness. But as for this particular video,
That's not a legal objection. That's just not.
our objection to this videotape stands. It's irrelevant. What does it prove or disprove?
All right, Mr. Carter.
I think we've done what the court asks us to do. I think it's clearly impeaching. And door closes. I'd like to show it tomorrow morning. The court calls his testimony. This is contrary to his testimony. Show it and move on.
Well, if you recall, my concern was that it just abruptly stops at one point and doesn't show him actually drive off. And his testimony is that he put the shoes in the trunk, as I recollect, and then drove from the scene. And it appears that he gets into the car, closes the door, and but the car doesn't move. But I have to tell you that given the crush of news photographers and other people, it's unlikely that he would have opened the door and gotten out and done anything other than drive off at that point, preferably driving over some of the reporters there. But I mean, I can't think that he would get out of that car and do other than drive away. So any other comment? All right, I'm going to allow the tape.
Thank you.
All right, anything else we need?
As I understand it, Mr. Darden is asking, does any other tapes be shown to this witness? No.
Okay.
All right, how much more do you anticipate, Mr. Carter?
With Detective Lang.
All right, what's your guess, Ms. Clark, as far as redirect?
How long was it?
Hour. So we should be able to conclude Detective Lang tomorrow morning?
For the record, we were given an hour and a half or so
Let's
of
see.
videotaped information just this past Friday.
6th.
And so the council was aware we
7th.
object to the introduction of any portion of that videotape.
March 8th.
And we would ask that council discuss with us his intention to use any portion of that tape prior to actually presenting it to a witness.
Guys, we're so close. We're so close to Mark Furman.
Or flashing it in front of the jury.
Okay.
All right, well, the court will view out of the presence of the jury any videotape before it's shown to the jury. All right, anything else, counsel, on this issue? All right, let's move on to the, I'm sorry, Mr. Bailey.
Witness list of last Friday remains constant. You had moved Furman up ahead of 2 others.
All right, so we're still on the schedule that the prosecution has previously provided the defense. Okay. All right, do you have is Mr. Hodgman available to discuss our discovery matters with Mr. Scheck? All right. Is he on his way down? Are the elevators operating? All right, Mr. Scheck, my understanding is this is just a matter of making additional samples available for longer periods of time.
There are 3 matters at issue.
All right, before is that what we're talking about?
Yeah, the one thing that I think was of the most immediate concern is there's a courier en route to Washington. I think we had raised that earlier with the court.
Well, let's wait till Mr. Hodgman gets
Right.
here. I just want to know if that's what the issue is.
Did you see the letter?
Yes, I got it faxed to me this afternoon. I read it once. What's our ETA on Mr. Hodgman?
Shoes, now identified as item number 415, are here. I received a phone call just as I was leaving for court confirming that those shoes had just been transferred from the property division to the scientific investigation division. So the shoes are not in Washington, D.C. They are not at the FBI lab. They are here in Los Angeles. We have a courier en route to Washington right now to pick up the socks and return with them to Los Angeles tomorrow. If the court will recall its order of February the 8th, the court stated that examination and testing shall be conducted locally unless good cause is made by affidavit or other similar showing. With regard to item 1, the socks and the shoes, I would submit that no good cause has been shown and that we will make those items available locally at the LAPD Scientific Investigation Division. But there is no need for the people to incur the additional expense of rerouting our courier to New Haven, Connecticut, and no need has been demonstrated.
All right, let's take it up item by item. All right, Mr. Scheck, with regards to the shoes and the socks.
Well, the first point to be made is that, as the letter indicates, and I'm sure we'll get into, there was a lot of confusion, unfortunately, on Saturday as to where important items of evidence were that impeded examination. And it was believed at the time on Saturday that those shoes were in Washington. So, and we spoke to Mr. Hodgman, called him before this letter was even faxed, apprised him of this situation. And I think it was his last inquiry just before he came down here, we was able to determine where the shoes were. So that's the reason. But the key point is the
Put all that
socks.
aside, Mr. Scheck. Forgive me for interrupting
Sure.
you, but let's sort of cut to the
Get to
chase.
the point.
We got the shoes, we got the socks. Both are going to be here. The shoes are here, the socks will be here tomorrow. Correct? Right.
That's the problem. As the court recalls, we set up this examination at LAPD painstakingly over the last 2 weeks. It was anticipated, certainly, that the testing at the FBI would be done. I think it was a week ago Monday, so that the socks would be here and we could have an examination of the socks, the shoes, the dress, the shirt, the relevant items of evidence, Mr. Bodziak's reports. So all that evidence could be looked at as a whole intelligently by our experts. As the court recalls, because of this courier problem, that they didn't want to send a courier out earlier in the week to bring the sock back so that it could be produced on Saturday. The sock was unavailable. I think.
Well, let's forget about all that. That's all in the past. The sock will be here tomorrow. The shoes are here.
Yeah, but-
How do we get them tested by the defense?
Well, the test and the examination has to be done by Dr. Lee, who
Okay.
is the one that has been doing extensive research into it. Dr. Lee was here, changed all his scheduling, came down here, was here to do this, couldn't get it done on Saturday. He's now in Denver. He has to go back to the East Coast. He has responsibilities there. And it seemed to us that the most expeditious and best thing to do in terms of expense, frankly, to both sides in this matter, was, since the courier was going out, that the socks could be taken by that one courier to Dr. Lee's laboratory in New Haven so that he can perform his tests and examination on that sock. The problem we have is that the conditions that Dr. Lee and Mr. Morton and the other experts have to work under at LAPD are far from ideal. In fact, in certain instances, they're inadequate for purposes of conducting these tests. They need their own equipment, special equipment, particularly for the examination of these socks and hairs and fibers we'll get into. So Dr. Lee has strongly urged us to try to accomplish that. And it seemed to me I had to bring this to the court's attention. I think we even raised it last week as a possibility when it became clear that no courier was going to be sent out last week to get the sock for Saturday, that there was a possibility when that courier came back that courier could, already in the East Coast, could go to Dr. Lee's lab and take it. We raised that last week. And we wanted to bring this to your attention immediately because that's critical evidence. It's coming in soon. And we want to have
So you're suggesting that we have a courier stop at the FBI, go to Dr. Lee's lab, and then bring it back here to LA.
That's right.
All right. What about the shoes?
Well, the shoes, obviously, we would prefer that he have those at the same time. But if all we can get is the socks, we'll take the socks because that's critical.
All right. How do you propose to look at and examine the shoes if they're here in LA?
Well, what we were able to do for the present period was look at one set of shoes in the lab. Obviously, the other set were there, but nobody knew it. I know that the examinations that Dr. Lee wants to perform on the socks, there's one separate set he wants to perform on the socks and one set that he wants to perform on the socks and the shoes in combination. But the more painstaking ones immediately just concern the socks. So that would solve a lot of our needs if he got a chance to look at those socks right away. The relationship of the socks and the shoes is something that is going to be later in the trial, but I would expect in the next 2 weeks the socks are coming in, and so he wants to see those.
All right, Mr. Hodgman, what is the what objection do you have to the socks going to Dr. Lee's laboratory other than the additional expense?
Your Honor, there's been no demonstration of good cause. I would point out to the court that based upon a syllabus of sorts that we presented to the court last week, that these socks have been examined by the defense on 4 occasions, including one several-hour examination by Dr. Lee at LAPD SID just a few weeks ago. So we have the matter of additional expense. We have the fact that these socks have been examined multiple times by the defense thus far, and Dr. Lee can come here. Part of the problem, as described or characterized by the defense with Saturday, is that they were trying to get a lot done in the same space. There's a conference room over at LAPD SID, which seemed to be suitable when Dr. Lee examined those socks the first time around a few weeks ago. On this particular occasion, this last Saturday, we had Mr. Morton at one end of a large conference table, Mr. Lee at the other end, and things were a bit crowded. If we removed half of the examiners for purposes of conducting a single examination, I think once the equipment is brought in, whatever equipment the defense wants to bring in, the conditions or the problem with the conditions will be solved. So the people object that there's no showing of good cause. We ask that this examination be done locally. In addition, Your Honor, we only have a courier who would be available to take the socks. We still have the matter of having a monitor or a special master or someone like that who would have to be arranged if we were to go to the New Haven lab. So our position is, let's have Dr. Lee come here and examine the socks at LAPD SID.
When do you anticipate in your consultations with Ms. Clark when these socks will be offered into evidence by the people?
Totally socks.
I can't address that, Your Honor.
When is Mr. Scheck, when is the students that Dr. Lee can come to Los Angeles and use lab facilities here and examine the socks?
I don't know the answer to that immediately, but I would just point out that before the socks were taken to the FBI for testing, when that was announced and decided, we flew Dr. Lee in for the first meaningful examination of the socks, first time any expert could touch and really examine the socks. He did that at the last minute. If you recall, we flew him down at 6:55 in the morning from Seattle to go to the lab. We got a microscope that was the best that could be obtained on quick notice, that was not nearly powerful enough. And he was able to essentially start a first examination. Since then, they've been tested again. There are complicated things he has to do. There's an infrared videotape that was taken by the prosecution's experts of the sock in various spots. They've had Mr. Englert look at it. They've had various different experts look at it for long periods of time. We really have to study the sock. The conditions, most respectfully, at LAPD and the various equipment that's needed are woefully inadequate for that purpose. And if the court desires an affidavit from Dr. Lee to that effect, immediately, I will locate him to get it. But the reason I want
is, when is he available to come to Los Angeles?
I don't think he's available, to my knowledge, to come to Los Angeles for at least the next week. And I know it's very difficult for him to make this time. That's why we tried to make these arrangements.
Are there any other
Saturday.
lab facilities here in the county of Los Angeles that Dr. Lee would find acceptable to use?
We've investigated this, and the problem is getting all the equipment that's necessary in one place at one time, and getting the material there. Frankly, the amount of money that was expended in overtime, in opening up the LAPD lab to give us an opportunity to go in there, where the facilities were inadequate for studying this evidence for lots of purposes, I'm sure cost money. I can't imagine that the cost of
None of that answers the judge's question. None of it.
this courier staying over an extra day to take the socks, or 2 days to take the socks to New Haven for purposes of this one examination, could possibly be as high as the costs of opening up that whole lab, arranging for things to be brought over, having a photographer come, having district attorneys and everybody else sit and watch, take notes, and make all those logistical arrangements.
There's no other lab facility here in the county of Los Angeles that's available to you for this testing that would be adequate?
We have made inquiry, and we have not found anything that approaches the instrumentation that Dr. Lee has available to him in his lab. After all, he's perhaps the foremost expert in these areas in the country, and he has lots of state-of-the-art equipment that are not available that we can find in any one lab in this immediate vicinity. So it would be.
I have to tell you, Mr. Scheck, that I agree with Mr. Hodgman's position that the indication was I would allow this testing to go on outside of the state of California if there was a showing of good cause, which I haven't seen here. I mean, we've talked about stereoscopic microscopes, which I'm sure they're a dime a dozen.
Oh, no.
Sure they are.
Dime a dozen?
$1,000 a day, was it $1,000 a day?
They're available here
Well,
in the county of Los Angeles.
there are other facilities and other kinds of tests that he, I think, intends to do.
All right,
He made
Mr.
that
Scheck-
point to me
Mr. Scheck,
strongly.
Then why don't you do this? Why don't you get a declaration from Dr. Lee as to what it is he wants to do, what kind of equipment he needs. I need a declaration from you that all of this equipment isn't available here locally and that there's good reason to have to do it otherwise. Then my probable, if I do grant that, I will probably require you to pay the cost for that,
Pay the cost of.
the additional courier.
The jury just left because they need to rewatch video that we've already watched.
Cost.
The additional courier cost of going out there. Well, I think that frankly, that would be far preferable to us and far less expensive for the city of Los Angeles and for everybody else. For us to pay that courier, I'm sure it wouldn't even be approaching what it takes to rent all the equipment and bring everybody over into a situation that isn't going to be as good as it would be if it were sent out there. So what I'm really urging the court is that part of the good cause is that if it's done the way that we urge it be done, it's cheaper.
All right, number two.
Your Honor, with regard to that, we would like an opportunity to be able to explore with labs locally, once we obtain the affidavit or declaration from Dr. Lee, what equipment he needs, because I believe it can be done locally. And we would prefer that it be done locally.
Well,
Those socks,
That's why I'd like to see an affidavit telling me what kind of equipment we need and what we're talking about.
see, that courier is going to be getting on a jet tomorrow morning in Washington to bring those socks back. I'm informed that the socks will be back here at 3 p.m. tomorrow. So that's the timeline we're dealing with. But Your Honor, our preference is let's do it locally. If it has to be an independent lab, then it can be an independent lab that has presumably has the equipment that Dr. Lee requires. And the defense has chosen.
I'm not restricting this to the county of Los Angeles. I mean, just any contiguous county. I know there's some good crime labs down in Orange County, et cetera, et cetera. I'm sure we can find a lab somewhere.
Yep.
Sheriff's lab, who knows?
And there's one additional wrinkle in the socks, Your Honor, and that is this. Pardon me.
It's a little late in the afternoon to be doing that to me, Mr. Hyde.
Mr. Scheck informed me that Dr. Lee would like to do some cutting with regard to the socks. And if that's the case, that's going to necessitate certain specialized personnel from on our part, to be able to observe what goes on. So that gets folded into the mix as well.
All right. Well, like I say, when I see the affidavit of
So
good cause,
get
I'll
the
think
time
about it.
personnel.
And we'll see. You'll have the opportunity to respond, Mr. Hodgman. All right, that one's still on the table. All right, number two, trace evidence.
Your Honor, with regard to number two, once again, we have a situation where this trace evidence, which other than the items from which it was collected, but otherwise specifically not specified in the defense request, has been examined by the defense. This, as the court will recall, the trace, that is the hair and fiber evidence, was examined by Mr. Schulberg in Virginia some months ago. In addition, Mr. Morton had an opportunity to view this trace evidence in Albany just a few short weeks ago. So again, as we have a request for movement of this trace evidence, I'm asking that it be done locally under the same terms and conditions as we're contemplating for item number one. That is, it can be done locally. Here, the defense was aware of the conference room situation. The setting was chosen. We opened up the LAPD lab with the understanding that this was going to be acceptable. And we receive a declaration today that somehow is unacceptable because the defense apparently tried to do too much on one day. So again, I would submit that if the defense is a little bit more reasonable in terms of what they try to accomplish over at LAPD, Mr. Morton's examination can be done at LAPD or in the alternative, some local lab nearby, without necessitating great movement of these items of evidence.
Mr. Scheck?
Yes, we would rely on Mr. Morton's affidavit. I beg to differ with Mr. Hodgman about what could or could not be accomplished and what space was or was not available and what was anticipated. We didn't anticipate that we would have to necessarily stay in that one room. A request was made to go into the microscopy room by Mr. Morton, and Matheson informed him that it was against policy for him to do so. I don't think that there's any serious question among criminalists, or frankly, even the people in LAPD, that the kind of examination that's necessary to look at all these hairs and fibers, as Mr. Morton describes, absolutely cannot be conducted under those kinds of conditions. It takes a long period of time to go through these bindles, some of which we have created because we found new evidence on the same key pieces of the same items that previously had been examined by the prosecution's experts. We found more. We want to look at all that together. Some slides have been mounted. To the extent that you can look at a mounted slide, it's easier. But it turns out, upon examination of the evidence, that most of this is not mounted. So what he has to do is carefully go through each of these things, look at them, decide which ones to mount. It's a painstaking process. It can't be done in a marathon session.
What I got out of Mr. Morton's declaration is that he says it's painstaking, it's time-consuming, it takes a lot of time, and I need more time. That's what I got out of the 3 pages here.
Yes, and also that the way that this has been done in the past in almost every other case that he deals with rare exception, is that ordinarily the evidence is simply sent to his laboratory by various jurisdictions in California, including Los Angeles prosecutors, Sheriff's Department on other occasions, and it's taken to his lab and he looks through it.
All right, Mr. Hodgman, why can't we do that in this case? Mr. Morton is local, semi-local, Alameda County, well-known to you, well-known to me.
And the reason why, Your Honor, is they've already had 2 shots at this very same evidence. Mr. Schulberg last fall, and the Albany trip, which was arranged at great expense, that the defense had 3 days to examine this evidence back in Albany, or at least the better part of 2 days. Mr. Morton was there. Why is it that we need to do it again? I haven't heard any good cause justification for that yet.
Well, let's assume that I accept the argument that there's so much of this stuff, this trace evidence, and that it's very time-consuming to look at. How would you propose we allow Mr. Morton 2 or 3 additional days to look at this stuff?
I would submit, Your Honor, that Mr. Morton, if you feel he needs 2 or 3 more days, but they have had time. But putting the time issue aside, we would like the evidence to remain locally. As the court sought fit in its order, we have a preference for this type of evidence to be examined locally. In this particular instance, I would submit we either use the LAPD facilities. Mr. Morton can bring in what he needs. Again, part of the problems this past Saturday was because they were trying to do too much.
All right. I prefer the evidence stay in this county is not a legal argument. It's just not.
Much in the space that was chosen. That can be remedied by simply being reasonable in terms of what they're trying to accomplish in the space that is given to them and in the time that is allowed.
All right, Mr. Scheck, Mr. Morton does not include in his affidavit any indication as to what equipment he needs for this
Yes, well, I think it's known to the prosecution that it's a comparison microscope, and the only one we were able to get from him down here that was like his was not, as he said, up to his standards of the one he has in Northern California. Now, this is in California. It's in Northern California. And there's, they wouldn't let us use the microscopy room at LAPD. It doesn't have comparable equipment in the first instance. And it is just not reasonable, given the fact that they had these fibers and hairs and were looking at them from the 8th of August through the 7th of September at the FBI and their facilities. This takes time. It is, we did the best we could under those circumstances in Albany. We've generated yet new evidence from the same items recovered at the scene. And frankly, right now, we're only focusing on the most important items of evidence that have been introduced and are going to be introduced in the trial. And there's a need for us to get this done expeditiously. He's willing to sit there, get rid of all his other cases, and sit there and get this done just by looking at this 3 days in a row.
What would be involved as far as courier and special master services?
Well, I would say this, at this point, given the problems that we have, I would welcome the appointment of a special master to go through this discovery. Nothing could be better from my point of view to try to work this out as best as possible. I don't know, it's up to the prosecution. I mean, they can have somebody sit in the room and photograph him looking at a microscope for 3 days, or they could do what's usually done and let him look at the evidence.
Your Honor, I would point out once again, there is still the issue of why, when they had the opportunity in Albany and time
Well,
in the lab of their choosing.
Yeah.
And LAPD will make the room available. They can bring in what equipment they want to bring in, and then it's Mr. Morton's time. LAPD will allow the time there at SID. Why do we have to move the evidence? No good cause has been shown.
all right. Mr. Scheck, I don't see any reason why we should do it this way. I think what you need to do, I agree Mr. Morton should have additional time to look at these things. The prosecution isn't willing to let it go to Alameda without a fight. I haven't seen anything here that the equipment is completely inadequate.
Well, I think he spells out pretty clearly about the working conditions. And
Working conditions doesn't tell me anything. What I need to know is I need a Model XYZ stereoscopic comparison microscope. You know, I need this light source, I need that. It's not available here.
he did indicate in his affidavit that in addition, a rented comparison microscope of limited capacity was made available. It takes about an hour to set that up. That was the best microscope. We got it from Mr. Sugiyama, I believe, that we could find in the area to do it for these purposes.
All right, so what's involved with bringing his microscope?
He can't do it. We've asked him that on a number of occasions. It's just not movable. It's planted in his lab, apparently. He says it's just not transportable. We've asked him to.
All right, what's the name of this microscope?
I don't know. I'll have to find out.
All right, have him call my clerk this evening with the name, number, model number, who manufactured it, who rents it. I'll find you one.
The
Or more
only other thing,
appropriately, my law clerks will find you one.
the only other thing I would note is that in terms of the working conditions, one problem is that every time that a bindle was opened or he was looking at a slide, somebody would come running over, take a picture of it. There was the danger of all the evidence, being blown across the table. It's very, very difficult and unusual circumstances. And I think
No,
everybody
sir.
there recognized it. It wasn't the nature of the room, it was the nature of the circumstances.
Okay, well, get me the model number, name, serial number, et cetera, et cetera. I'll find you one. All right, last matter are the updated tracking lists. Mr. Hodgman.
Your Honor, with regard to that, I have to rely upon information I was given by Mr. Matheson last week. With regard to the sets information, there was an attempt to achieve a printout of the information last week, and apparently the printer, be it antiquated or otherwise inadequate, broke down. There was some sort of meltdown with the printer.
What's the bottom line? When can you have these things available?
Mr. Matheson was off today. I don't know. He informed me last week that they were getting some new software which would allow them to be able to print out the sets information, but that was going to be arriving within 2 weeks of last week. And with regard to the E-pins information, at this point, I don't know.
All right, Mr. Matheson will be in tomorrow?
Yes.
All right, why don't you report back to me by the close of the morning session tomorrow as to when these items will be available, because I think the defense is entitled to look at those. All right, anything else?
Yes.
Let's see, if I may, Your Honor, just one point with regard to the hair and fiber information. I realize the court is just trying to craft a way for the defense experts to take a look at it. I would simply point out they've had opportunity and time before. We've had the Albany.
Well, the problem is every time we look at these things, though, there's an ever expanding number of items to look at. And this stuff really is time consuming. It really is. If you've ever done any microscopy before, it's very tedious, time consuming stuff to do.
Very well.
one more matter I should bring to the court's attention. I didn't include the letter because I was making inquiries about labs in the Los Angeles area and trying to get experts. When we were in the lab on Saturday, we were given access to the original copies of notes by criminalists. And an examination of that reveals to us that we need to have those looked at by a question document examiner. And I can provide to the prosecution the exact items that we have in mind. I know Mr. Goldberg was sitting there with me for quite a few hours and saw me tabbing every page, so he knows exactly what we're looking for or what items are at issue. But I want to put him on notice that that's what we want to do with that notebook of items that were filled out by the criminalists, the originals of which we first saw on Saturday. Dr. Lee took a look at those as well, and we know we want an examination of those documents. I've made inquiry of a lab in Los Angeles that I know could be available, and Mr. Harris. However, he can't do the case because of other time commitments. And so I'm looking for another expert who I can have go and use this lab in Los Angeles. I assume that that plan, given the constraints here, is a sound one. But I wanted to put them on notice that that's something we want to do right away.
All right.
Well, Your Honor, that may be something they want to do, but I haven't heard any justification or reason why. If the defense, either by way of motion or by way of letter, perhaps.
I assume that was just Mr. Scheck putting you on notice that that's something that may occur.
Okay.
Yeah. All right.
And frankly, I don't know why. I guess my problem here is I understand the difficulties involved in this case, but we are only trying to get an opportunity to examine the evidence before it's put on. We're in an unusual situation. I've looked at the court's ruling on the testing question and read it again and again and again. And my concern that I've expressed before to the court, and just to put it on the record, is that when the court made its ruling that the prosecution could continue testing through the trial without any particular time limits, balancing the defendant's need for a speedy trial and the situation we were thrown into. One consequence, however, that wasn't specifically addressed or even argued by me or considered is that as all these items were essentially being frozen for purposes of potential DNA testing, genetic testing, and whatever other kinds of testing they wanted to continue to perform as this case went on, that made it impossible for the defense to get access to do its testing until the prosecution was finished. So what we have going on in this trial is an unprecedented situation from the point of view of our experts who...
Well, Mr. Scheck, I've agreed that I think you're entitled to test this stuff.
Thank you. Thank you.
All right. See you all tomorrow, 9 o'clock.
Sure.
Mr. Douglas.
May it please the court. Good morning, Your Honor.
Good morning.
Your Honor, there really is, as I see it, no real basis to challenge the relevance of the sought information and the fact that, in fact, this information would be critical to a full cross-examination of Mr. Furman. I think, Your Honor, in this regard, it would be important to review not only the personnel files from Parker Center, but any relevant personnel files from West Los Angeles as well. I'm unsure whether the court had the benefit of reviewing each of the separate personnel files last fall when the court reviewed and visited this question earlier concerning Mr. Furman. But I specifically in this motion, this amended motion, sought to have the internal affairs investigatory files of each particular office because I'm informed that it is the practice of the Los Angeles Police Department to retain a personnel file at the local division level and a separate file downtown at Parker Center. There are, Your Honor, I believe, 3 areas of inquiry that I do not think there's really any dispute as to the wisdom of having an in-camera review. And all that we are seeking by this motion, again, is an in-camera review. I think that the court can take notice of the record that was made in the other hearing, the challenges that were made there as to the propriety of examining the personnel file of Mr. Furman, and whether or not there are issues of relevance that
Today's has been really easy because I went and did laundry.
may be germane to discovery. The 3 areas that we are seeking, though, concerns an investigation that was published, that was conducted by the Internal Affairs Division after Mr. Tubin's article was released in the New Yorker magazine. The details of that investigation, Your Honor, will impeach witnesses who may well testify in the future, but may also be very germane to our attempts to further impeach witnesses who have testified in the past. I am struck, for example, that Officers Risky, Rossi, Lang, and Phillips were all present at the scene before the arrival or near in time to the arrival of Mr. Furman, and I am certain, or I suspect, that each of these officers were among the 14 or so that were interviewed in connection with that earlier investigation. I think it also very important, Your Honor, that the investigation over the possession of some cartoon or other picture that may have included a Nazi-like symbol or insignia is another matter that has some possible relevance to a full cross-examination of Mr. Furman. This information, as the court is aware, came to everyone's knowledge through the district attorney's office, who informed both counsel and the court of their awareness of this investigation. We were also informed in chambers of the DA's awareness of an investigation that occurred over statements allegedly made by Mr. Furman, suggesting that Mr. Furman may have had some intimate knowledge of Ms. Brown Simpson, or in fact, portions of her anatomy. Clearly, both areas of inquiry are very germane to the issues that we have put forward and to the areas that the court has already ruled is relevant. As to the third area, certainly, if in fact there's any proof that there was some personal contact or acquaintanceship between Mr. Furman and Ms. Simpson, that would be very probative in providing perhaps some bias or basis for some other harboring of ill will or motive against Mr. Simpson in particular. Certainly, if there is something to suggest that Mr. Furman was in possession of some Nazi-like symbol or other cartoon or another in any other context, that also would be very relevant to our claim that Mr. Furman may well harbor certain racial attitudes or thoughts or opinions that might be contrary to a fair airing of the evidence in this case, and that might be very relevant to a jury's assessment of his credibility as a witness. I think that there is no challenge that these investigations existed. I think there can be no real contravention that in fact it is necessary for a full examination of Mr. Furman that we receive these documents. These are not matters that we're on a fishing expedition about or pulling out of thin air. In 2 of the 3 matters, we were informed by the DA's office that in fact these investigations had recently been completed and that the only mechanism by which the documents could be obtained would be by the filing of this motion.
Thank you, counsel. Mr. Walsh. Good morning, sir.
Good morning, Your Honor. I have a couple of points upon which I agree with Mr. Douglas and a couple that I disagree. First of all, I certainly agree that it's appropriate to have an in-camera review of any documents which the police department might possess which bear on the matters raised by Mr. Douglas's motion. Second, I agree that this is a continuation of a previously held Pitchess motion, and that we are not challenging materiality. However, a determination of relevance, unlike Mr. Douglas's position, will be made by you in chambers pursuant to the provisions of Evidence Code Section 1043 and 1045. And assuming that there are documents which relate to the matters described in Mr. Douglas's motion, I have confidence that the court will make that determination of relevance after it has had the opportunity to review those documents. And we're prepared at this time to go in chambers at the court's convenience.
All right. Ms. Lewis, do you wish to be heard on behalf of the prosecution?
Only to say, Your Honor, that I am confident the court will find nothing within any of these files to be relevant to these proceedings.
All right, Mr. Tortolo.
Morning, Your Honor. Basically, I echo what Mr. Walsh said. With respect to the personnel files, we have no objection, Your Honor, as we didn't have an objection in August, reviewing in camera in accordance with the evidence code, Detective Furman's personnel records. We didn't have a problem then. We don't have a problem now. As to the alleged rumors that are part of an alleged internal affairs investigation, we don't know anything about that. I only know what I read in the paper. One of the rumors was that with respect to the internal affairs investigation, Detective Furman has no information as to what those are about. I have no information. As Your Honor knows, internal affairs investigations, if one is taking place, go in a process. They interview different officers. To ask that the court order the Internal Affairs Division, the LAPD, to release whatever material they have as to an investigation that may be in process would be very unfair to Detective Furman, if indeed it was about Detective Furman. Now, these are only rumors, unsubstantiated rumors. And I would say with respect to the personnel files, we have no objection to Your Honor reviewing those in camera. We didn't the last time. And I'm confident Your Honor will find there's nothing in those files that would be relevant to these proceedings. But to start digging into internal affairs in connection with an investigation that's in some stage of its investigation is terribly unfair. Wait until it's completed, if in fact there is such an investigation. But these are just unsubstantiated rumors that were floated up, and all of a sudden I read in the LA Times that the Internal Affairs is allegedly investigating rumors with respect to Detective Furman.
All right.
So I would ask that you deny the motion as to the internal affairs and that you would review Detective Furman's personnel records in camera.
Thank you. Thank you, Mr. Tortolo.
Mr. Turlow wasn't privy to the conversations in chambers which gave rise to the filing of this motion. But we were notified by the district attorney's office that there was an internal affairs investigation. And it had been hoped that the DA's office would be able themselves to obtain the results of that investigation at its conclusion. Once the investigation had been concluded, we were then notified by the DA's office that they would be unable to obtain the results of that investigation, save for by the filing of this motion. And it was not any rumors, but our being placed on notice by the DA's office that there was this investigation, that it had been concluded, and that the only way that the results would be released would be by the filing of this motion that instituted this procedure today. And we are specifically looking at the Internal Affairs Division and those records, and that was specifically identified in my request.
Thank you, Mr. Douglas. Ms. Clark, let me ask you, when do you anticipate, in the scheme of things, assuming that we finish Detective Lang today, when do you anticipate calling Detective Furman as a witness?
Mr. Darden informs me that he will be following Detective Lang.
All right. Mr. Walsh, then what I'm going to do is I anticipate it will take us the remainder of the morning at the very least to conclude Detective Lang. We have not finished cross-examination. We have redirect, recross. Re. Okay. What I'm going to do, Mr. Walsh, is the custodian records present?
Yes, he is, Your Honor.
All right, I'm going to order that custodian records. Who is that person?
Sergeant Jack Rose, Your Honor.
All right, Sergeant Rose, I'm going to order you return to this courtroom at 12 noon with the personnel records that have been mentioned.
Yes, sir.
All right, thank you. Council, I'll conduct the in-camera review at noon time. I'd like to start with the jury, get that done, and then I'll conduct the in-camera over the lunch hour. All right, anything else? All right, thank you, Council.
Is he gonna get internal affairs documents on what
All right, Mr.
Furman did?
Cochran, Ms. Clark, anything we need to discuss before we invite the jurors to rejoin us? Ms. Clark? Ms. Clark? Anything else we need to discuss before we invite the jurors to join us? All right, Mrs. Robertson, have the jurors, please.
Okay. This is a good time to stop. Dawson, Georgia already went live, and I'm not recording it. I need to get busy. I need to get to work. We're that much closer. We're a couple days away from Furman. We just got to get through it. Thank you so much for coming out today, guys. I really appreciate it. Thank you. I shall see you all again very, very soon. I hope you guys have a good day. I won't see you tomorrow because I work a double today, but I'll see you the next day. Bye, guys. Happy birthday, CJ.